the law, and ignorance is no excuse. Your freedom lies in knowing the law of the land. It's the Law is brought to you by Gulf American Fire and Casualty Insurance Company of Montgomery, Alabama, who write all types of fire and casualty coverage through the independent insurance agents, and by WSFA TV in cooperation with the Montgomery Bar Association as a public service presentation. Did you know that in addition to writing all types of fire and casualty insurance, Gulf American also has a bond department? This department gives immediate, and I mean immediate, service on request for court or fiduciary bonds. It means a lot to the members of the Bar Association to have an Alabama company standing by to serve their clients without delay or red tape. Gulf American issues a special invitation to all lawyers to call on one of its independent agents when a judicial or court bond is needed. These same agents, your independent agents displaying this big I seal, are anxious to insure you against fire, windstorm, damaged suits, theft, and a host of other perils that can turn a happy home into one of misery because of the lack of proper insurance protection. And remember to ask your big I agent about Gulf American's special homeowners package policy, granting better coverage for approximately 15% less. Your big I agent gives you continuing personal attention 365 days of the year. So start enjoying the security of having the finest insurance protection available with Gulf American homeowners policy. See your independent insurance agent displaying this big I seal and ask him about Gulf American.
Now here is your moderator, James J. Carter.
Good afternoon. The Bar Association welcomes you to another series of It's the Law. This afternoon we have a very distinguished panel of Montgomery lawyers. I would like to introduce them to you. First, Mr. J. Mac Jones of the firm of Jones, Murray and Stewart. Mr. Vaughn Hill Robinson of the firm of Hill, Robinson and Belser. Mr. John C. Godbold of Godbold, Hobbs and Copeland. And Mr. Robert E. Steiner III of Steiner, Crum and Baker. This being our first program, we are not going to ask questions sent in by the audience today. Instead, we lawyers have talked about common questions that are asked lawyers and common misconceptions about various problems in law. We'll start off now with Mr. Robert Steiner, and I'll ask him this question. Bob, why will a friend or acquaintance of mine occasionally ask me to endorse a check for him before the neighborhood grocer will cash it? Is this just for identification purposes?
Like, yes, Jim, your friends probably think you have better credit than they do. By endorsing the check, you become liable to pay it if for any reason your friend does not. And when this happens, when you endorse the check, you in effect just guarantee that that check is going to be paid.
Mr. Jones, is possession of an abstract of title proof of home ownership?
No, Jim. Of course, a lot of people seem to be under the impression that it is, but an abstract is merely an outline of the public records relating to the ownership of a tract of land or parcel of real estate.
What about a warranty deed?
Well, in like manner, the possession of the deed would not be any real evidence of title. The recording of the deed is the really important thing rather than the possession of it once it's delivered.
John, this is a question I know you've heard many times. It said, I have a lawyer working on a case for me, and I've learned that the lawyer on the other side is one of my lawyer's best friends. Do I need to get another lawyer?
Jim, it would be hard to answer whether the man needs another lawyer or not, but he doesn't need one for this reason. Of course, the lawyer's test of whether he does his job is his loyalty to his client and his effectiveness and the manner in which he performs his job. And the lawyer's friendship one for another does not affect the manner in which they conduct the business. In fact, most of us lawyers, I expect, enjoy contested matter of giving a licking to one of our friends rather than to somebody we don't know.
In other words, friendship, as far as that goes, sometimes ends at the courthouse door.
That is right. So it does.
Now, Vaughn Hill, and this is another question. can a person represent himself in court without a lawyer?
Yes, Jimmy, he can represent himself in court without a lawyer. Of course, in capital cases that are tried at our circuit court, a lawyer is appointed to represent an indigent defendant, and also a lawyer may be appointed in federal court where a criminal case is brought against him. But it's not mandatory that a person be represented by a lawyer.
Also, for the benefit of the client or the person who's in court, it's not recommended that he go in court as his own lawyer, I think. John, this man asked me, he says, a Montgomery police officer gave me a ticket for running a red light. I don't think I'm guilty. What can I do about it?
Jimmy, I assume that there's been no trial and that the person has not been already found guilty. If he feels he's not guilty, he can go to the recorder's court at the city hall on the proper day and have a trial, take his witnesses with him and have a very informal trial. The court may find him not guilty, and if the court finds him guilty and he desires to do so, there are provisions for taking an appeal from that.
Vaughn Hill, this is a question that I think might be of general interest. Alabama has had a lot of publicity in this regard, but this person says, my cousin lives in New York and wants a divorce from her husband. Can she or her husband come to New York from Alabama on a visit and get a divorce?
So the answer to that question very definitely is no. The Supreme Court of Alabama has so ruled. In addition to that, prior to the ruling by the Supreme Court, our local bench adopted a rule of the court whereby the residence had to be actually proved, not only just alleged. I also believe in connection with that, possibly last year, the State Bar took some action on that, and Jimmy, you as president of the State Bar would probably add something with respect to the action of the State Bar in connection with the so-called quickie divorce.
Yes, the State Bar Commission amended Rule 25 of the Rules of Practice and makes it an unethical practice for a lawyer to file in court a bill for divorce when he knows or has reason to believe that one of the parties or both of the parties are not residents of Alabama. And if a lawyer does this, knowing that one of the parties is not a resident of Alabama, under the rule as it now stands, he is subject to discipline and possible disbarment. Now, Bob, is it true that a man must will each of his children at least $1 or his will is no good?
No, Jim, there is no such requirement. However, it's usually advisable for a person writing a will who doesn't plan to leave anything to one child or to any of his children, simply to mention the fact that he's not forgetting them or anything like that, but he feels they're otherwise adequately provided for, or that he's leaving it to his wife to take care of the children.
But what about a wife or a husband cutting the other off without anything in the will?
Well, this is one of those unfair areas of the law so far as men are concerned. A wife can leave her husband entirely out of her will. However, the law does not permit a man to leave his wife completely out of his will.
Now, Mike, we're speaking of wills. How long does a will last? And can my will affect my management of my property?
Well, Jim, a will does not become effective until death and may be revoked or changed at any time. Since it is not effective until death, then obviously the testator may continue to deal with his own property as he sees fit up to that time. Every person's will, we think, though, should have a sort of periodic medical examination. Will should be kept up to date, and any major change in family or property situation or in the tax laws can easily make a will obsolete.
Vaughn Hill, this person asks, the deed to our home is in the name of my wife and me. If one of us dies, does the other automatically own our home?
Jimmy, the answer to that is no, not automatically. Within recent years, there has developed the practice of drawing deeds under what we call a survivorship provision, which is to put the title to the property in both the husband and wife with the right of survivorship stated in the deed. The deed might also be drawn to the husband and to the wife, but without that survivorship provision. Then each owns a half interest, and the half interest of the husband and wife on death would either pass by will or under the statute of descent and distribution.
Now, John, many people ask about lawyers' fees, and many people are concerned about going to a lawyer because of the question of fees. I know you've been asked, as most lawyers have, if I talk to a lawyer concerning a possible legal problem, will he charge me a fee?
Jimmy, I think almost all, one can talk to almost any lawyer about, at least have a preliminary talk about his legal problem without being charged a fee. Once he has given the lawyer an idea of the type of problem it is, how big it is, what's involved, then he's in position to, the lawyer's in position to state in advance, if necessary, generally what sort of fee will be involved for handling that particular matter. For the preliminary discussion, no lawyer charges a fee for that.
Bob, this question says the sheriff has delivered some papers to me which say I owe some damages, and I should appear in court on a certain date. The statements in the papers are not true at all. Should I just ignore the papers?
Well, Jimmy, the statements in the papers may be untrue, but you certainly, or your friend certainly, had better not ignore those papers. Once you've been served by the sheriff with a lawsuit, the thing to do, in my opinion, is immediately to contact whoever your lawyer is and let him then prepare the answer or the papers which will allege and tend to prove that you are not guilty of what you're charged with.
Now, Mike, this may be a supplement to one of the earlier questions that I asked you when we talked about an abstract or warranty deed, and this question poses this problem. Is a warranty deed from a responsible party adequate protection to a home buyer?
Well, we would certainly not feel so, Jim. A warranty deed is a particular type of conveyance, just as any other sort of a deed. And it might be comforting to know that the person who warranted signed the warranty deed was financially responsible, but it's certainly not a substitute for adequate title examination. Title defects have a way of lying dormant for years and perplexing buyers long after they've paid for the land and long after the fellow that signed the warranty might be dead and gone.
Bob, in understanding the relationship of lawyers, people ask quite often, why do lawyers defend people who are guilty of a crime?
Well, Jim, no person is guilty of a crime until the jury and the court have heard all the evidence and decide that he is guilty, and guilty beyond a reasonable doubt. Every person has certain constitutional rights, and a lawyer's job is simply to make sure that a criminal defendant or a defendant in a criminal case receives a fair trial and according to the rules of the game.
We talked a moment ago about lawyers' fees, and this question brings in lawyers' fees and also a field of practice that has grown in recent years, that is concerning automobile accidents and the injuries resulting therefrom. This person says that someone ran into our car and hurt two members of my family. We can't afford to pay a lawyer to handle the case. Can we do anything about it, or must we just forget it? John, I'll ask you to answer that one.
Jimmy, I assume that the question is directed to a civil suit for damages and not to any sort of criminal prosecution.
I assume so.
In that case, nearly all the lawyers who handle practice of this type, and that includes just about all the lawyers, handle cases of this nature on a contingent basis, which means that if the lawyer is able to, if the claim is a just one and the lawyer is able to obtain any recovery for his client, either by settlement or by suit, the lawyer is then paid an amount equal to an agreed percentage of the settlement or recovery. In Montgomery, The percentages on contingent fee contracts usually run 25 to 40%. If the lawyer is not able to collect anything for his client, then he isn't paid anything.
See. If on Hill, this question says I have a problem. I would like to talk to a lawyer about it. But this matter is personal and confidential, and I don't want any knowledge of it to ever get out. What can I do, if anything?
That person can well talk to his or her lawyer, because the communication between lawyer and client is highly privileged. As a matter of fact, anything that is said to a lawyer by his client or by someone who has a relationship of lawyer-client with him is privileged to the extent that even the confession of a crime to his lawyer, the lawyer cannot be forced to make any statement regarding that confession or any conversation that's had with his client, with one exception, and that is that if that prospective client gives evidence to the lawyer of an intention on his or her part to commit a crime, then the lawyer is not privileged in his communication with that client.
Now, Mike, we come to another question involving automobile accidents. My 15-year-old boy took our car without his mother or me knowing he had it. He had a wreck and is being sued for damages. At his age, since he's only 15 years of age, can they get a judgment against him?
Well, if he is guilty of negligence, the fact that he's 15 would not prevent the plaintiff from getting a judgment against him, and it would be a very serious thing that would plague him for many, many years. And of course, even though the parents did not give permission for the minor to take the car, they might also be liable depending on the circumstances.
Now, John, in buying real estate, people sometimes run into many problems, and I think this is a common problem that lawyers have been asked time and again. I bought a home 4 months ago under an FHA mortgage. There's some defective work in the construction, and I can't get the builder to fix it. Can I just quit making payments on the mortgage until the house is fixed?
Jimmy, this is a question which all of us have been asked a lot. The lending agency which lends the money secured by a mortgage to a person who buys a home has nothing to do with whether the builder of the home has built it properly or performs his contract or not. The purchaser's contract with the builder of the home is entirely separate from his mortgage transaction with the lender. And if he doesn't make his mortgage payments, the lender will be entitled to foreclose. This problem has been asked so much that many of the lawyers here in Montgomery now put a paragraph at the bottom of their loan closing statements calling the purchaser's attention to the information I've just given.
Would that same thing, John, be true, say, to the purchase of an automobile? Say a man buys an automobile and becomes dissatisfied with it, and he's financed it on the time payment plan. If he gets dissatisfied, he can just turn the automobile back and not have to pay anymore.
No, he can't. Of course, if the original seller of the automobile is still holding his note, he might have a good claim back against him. But if the lending agency is an independent third party not involved in the original transaction, he'll just have to make his payment.
I see. Ron Hill, this man says, I've lived in the same home here in Montgomery for the past 40 years. Now the state's planning to build a highway right through my home site. Can they make me sell my home to the state?
The state can condemn that home on the theory that it is a public necessity and convenience. However, in condemning that home, the state, by the Constitution of the United States, as well as by our own state constitution, and as well as by statutory provisions, must compensate that owner for that home. And the amount of that compensation may ultimately, and usually is, ultimately decided by a jury of 12 of the peers of the person whose property is being taken.
Bob, I don't know how many times you've heard this question, and I have, and every member of this panel. But if it's a situation where the man and the wife say they've moved to Montgomery 6 months ago, and they leased an apartment for 1 year, He says, I'm now being transferred on my job to another city. Can I break my lease?
Jim, unless there's some provision in the lease that gives the lessee, the man and his wife, the right to terminate the lease if he's transferred, the answer to the question is no. He signed the contract to rent the property for a year. He's got the right to pay for it for a year.
And it's something that a lot of people don't understand, that a lease is a two-way street. He couldn't break it anymore. The landlord could come and say, now I want my property back before the year's up because my son's coming back from the Army. It's something that holds both of them for a year. And Mike, this one is my neighbor who owns about as much property as I do, went to a lawyer and had a will made. My neighbor let me read the will, and it looks just like what I want. Can I simply copy his will and save paying a lawyer for drawing a will for me?
Well, I'm sure that's been done, and probably sometimes it works. Not impossible for a person to draft a perfectly adequate and valid will for themselves, but some people have been known to take out their own appendix. It works sometimes, and a will is a highly technical thing, and will contests, which this sort of a practice would tend to lead to, are rather expensive. Lawyers don't make much money drawing wills, but it's a form of preventing trouble and expense after a person's death.
Bob, you're chairman of the grievance committee of the Alabama State Bar. This question is asked of me sometimes, and perhaps of you and other lawyers. Does the Bar Association ever actually discipline or disbar any lawyers?
Yes, Jim, the State Bar Association and the Montgomery County Bar Association, and I'm sure all bar associations, have what's known as a grievance committee. Any person who has a complaint to make against any lawyer who's a member of that association can contact the grievance committee. The committee will investigate immediately, and if that lawyer has been guilty of some violation of the canons of ethics, he'll be prosecuted.
Do those prosecutions receive much publicity?
Again, the investigation, Jim, generally receives none. The prosecution can or cannot receive publicity depending entirely upon the degree of the crime, the degree of the violation, I should say.
So the answer is that the Bar Association does actively listen to complaints, investigates complaints, and takes action where it's warranted.
And makes no effort to hide any violation.
I see. John, this is a very interesting question, and I hope you have the answer to it. This man says, my wife is spending too much money and I want to stop it. Can I run an ad in the paper and notify people not to sell anything, and that if they do, I will not pay for it?
Jimmy, I wish it were that simple. The running of the ad really, as a practical proposition, does almost no good. A husband is responsible by law for supplying the necessities of life for his wife and family, and that has come to embrace nearly everything we buy. And such an ad is of no use whatsoever with regard to the necessities of life, and though it might possibly cut off liability for certain luxuries, but even that's doubtful, and as a practical proposition, the ad really does nothing except get a man's name in the paper.
Well, John, it does give him the satisfaction of saying, I got an expensive wife and I sure don't like what's going on.
Well, that's about all you'll get out of it in a bill from the newspaper.
Now, speaking of family finances, this question would be somewhat in line, Vaughan Hill. My wife and I have a joint banking account. If one of us dies, does the other one get the whole bank account?
Not necessarily, Jimmy. The common conception, I believe, is that if it is a joint bank account, on death of one or the other, it automatically goes to the other, the surviving one. However, that deposit is there under a contract with the bank. And that contract may or may not specify a survivorship provision. And if I might make a suggestion in connection with that, those who do have these joint bank accounts would do well to check with the bank to see that it does have a survivorship provision in it if that's what they wish. The present practice, as I understand it, with banks is to provide that survivorship. But there are older contracts that did not, and not all of the present ones do.
Now, Mike, we get to the field of taxes now. Do I have to pay any income taxes if I sell my home?
Well, of course, Jim, profit from the sale of a house is no different from any other profit and is, of course, taxable. There is an exception in the present federal income tax law where a person sells his home place, and if he, within a year after the sale, reinvests all of the proceeds of the sale in another home, then his profit would not be taxed.
Bob, this person says, must I have a will? We've talked a lot about wills, and he wants to know if that's an absolute requirement. If something happens to him, must he have a will?
No, there's no requirement at all that a person have a will. The statutes provide how the property devolves, descends to his heirs after his death if he doesn't have a will. The principal advantage of having a will is that this person can control exactly how his property is to go, no matter what the statute on the subject might be.
Does he save any money by having a will? That is, on administration expenses?
Generally, yes. He will save court costs, bond fees, things of this nature. It is less expensive to have a will.
Vaughn Hill, why do women serve on juries in federal courts and not in the state courts?
Well, Jimmy, that's pretty simple to answer. The federal law authorizes it and permits it. The state law does not authorize or permit it. That's the reason that they serve one place and they don't another.
Simply a matter of statutory
Right.
provision. Now, John, if you have life insurance, is a will necessary? Or to put it another way, does life insurance take the place of a will?
Life insurance doesn't take the place of a will, Jimmy. In fact, generally they operate in completely different areas. The life insurance policy is a contract between the insured and the insurance company, and generally those policy proceeds are paid to the beneficiary that he designates in that life insurance policy. And generally he can't control that designation of beneficiary by provision in the will. And of course also there are many areas and problems that a will deals with that are not in the area of insurance at all.
I see. Now, Mike, what is the best way to conduct a small business? As a partnership or as a corporation? If you can answer that briefly.
Well, Jim, most of these questions have been pretty straightforward with pat answers, but there's no pat answer to that question for sure. It depends on the facts of the particular business situation. There are advantages in some situations to having a corporation, and in some instances a partnership is much to be preferred. And this is something that just has to be analyzed in relation to the problem that's confronted.
I see. Now, next week, ladies and gentlemen, It's the Law will be back at this same time. The subject will be real property law. Mr. Saul E. Brentsfield, Jr. of Montgomery will moderate that program. If you have some particular questions with reference to real estate law, we invite you to send them in. Now, this panel does not attempt to solve legal problems for you. It does attempt to answer some questions of general interest. And if you do have a question of general interest regarding real property law, send them in care of this station, and next week the panel will attempt to answer them. In the meantime, it's been a real pleasure to be with you, and on behalf of myself and the panel, we wish you a pleasant good afternoon.
It's the Law is brought to you every Sunday afternoon at 4:30 by Gulf American Fire and Casualty Insurance Company of Montgomery, which suggests that as to legal matters, see your lawyer. For insurance, see your independent agent displaying the Big I seal. And by WSFA TV in cooperation with the Montgomery Bar Association as a public service. If you have a question you'd like to ask, send it to It's the Law in care of WSFA TV in Montgomery. This program was pre-recorded on videotape for presentation at this time.